all those involved at each and every stage of the building process, including builders and other professionals, owe a duty of care and will be held liable. This duty may even extend to the suppliers of the building products, as well as service providing professionals. But there's more. Hello and welcome to the third episode of our podcast. I'm Richard Kocher. I'm back to guide you through the ongoing changes reshaping the building and construction industry in New South Wales. Today, in this third episode, we'll be briefly talking about the duty of care under the proposed building bill, ensuring compliance and avoiding liability. We'll look at the tightening of the duties of professionals in the industry, and we'll also touch on the important High Court case, Pafburn, and the overall impact these developments will have on you. So thank you for tuning in again. This will be an important episode, and I can't wait to fill you in on what's been happening. In the first episode, we canvassed the why behind the changes in the industry. In the second episode, we looked at some of the proposed licensing changes. This episode will tie some of these topics together by looking at the duty of care. Yes, this is where all these changes come together. The issue of confidence in the industry by the public is the reason for the changes. The changes in licensing are there to ensure that qualified people do the work. And the developments in the duty of care mean that people qualified to do the work need to, take care when doing the work. Again, understanding these issues will help you compete successfully and get ahead of the game. The upcoming changes cast a very wide net on those who may be deemed responsible for defects. Irrespective of whether the defects are serious ones or minor ones. Generally, given the way that the changes are planned and given the developments, this wider net will provide a more unified statutory duty of care regime for building work in New South Wales, which duty is owed to both current and future owners. So what does that mean for you? You will need to know that the changes are structured in such a way as to lead potential claimants towards builders, developers, and others who are deemed responsible. For example, the proposed changes seek to spread the blame for careless work to a variety of entities and people. The changes refer to persons who arranged for, or facilitated, or otherwise caused, whether directly or indirectly, the building work to be carried out. You will need to be aware that this will effectively include the proliferation and extension of the duty to take reasonable care to not only some part of the building work, but also effectively to various stages of the process, including inspection, subdivision, certification, as well as the whole building process itself. It's an overall net. I repeat, the changes mean that all those involved at each and every stage of the building process, including builders and other professionals, owe a duty of care and will be held liable. This duty may even extend to the suppliers of the building products, as well as service providing professionals. But there's more. Late last year, the High Court of Australia, in a case called Pafburn, ruled that builders who are head contractors, as well as developers, yes, developers, are 100% liable for all the defects. This is the case even when the defects are not caused by the head builders, but by their contractors. It may seem unfair, but the High Court clearly said that people like developers and head contractors actually, and these are the important words which they use, delegate or entrust the work so they remain responsible. It's like you as a developer or a head builder are the employer and the subbies are the employees. You as a developer or the head contractor remain responsible for the subbies failing their duty of care. failing to do their job. Some people believe that the owners need to prove the breach of duty by the developer or the head builder for the liability claim to stick. Sounds reasonable, but we here at Chryson, we read Pafburn differently. The owners only need to prove the breach of the duty of care by someone, say by subbies. If the owners succeed in that, then the blame comes back to you as a head contractor. Of course, you can then cross-claim against the subbies, but all this means that the buck really stops with you if you were the developer on the project, and if there was a breach of the duty of care, you will be remaining responsible. As they say, prevention is cure. It's better to prevent these problems rather than to go through the headache of cross-claiming against the subbies who may or may not actually be able to pay you back for the owner's damages. Non-prevention means that you place yourself at risk. That's why it's important to know what you should or shouldn't do, and to have the knowledge at the right time to prevent all the hefty costs which come from litigating these matters in court. Before we wrap up, I will just remind you that in our next episode, episode 4, we'll take a good look at inspection and enforcement, preparing for building commissioners' powers. We'll be highlighting new enforcement mechanisms and what they mean for your projects. Again, thank you for joining me for this third episode. As always, if you have any questions or need any advice about these changes or about your business generally, the team here at Chryson is here to help you. We'll soon be publishing a detailed paper on the Pafburn case, as well as a very useful and handy ebook, which we believe will help you navigate through this, what is a very rough terrain sometimes. Don't forget to subscribe so you don't miss what's coming. Till next time, stay informed and stay ahead. Thank you.